Good morning. So today we are going to understand that how the procedure in a civil suit works. We all know that the civil suit lasts for years. The adjudication of the civil suit takes years, and it is very time consuming process and a hectic process, and parties to the suit always find it difficult to get the proper adjudication of their suit on time. So in today's video, we will learn that what is the procedure behind the civil suit and why it takes so much time for its adjudication. We, in the while understanding the process, we will also learn that what actually the rights we do have while our civil suit proceeds. So let us understand that. First of all, filing of the plaint is the very first step of our civil suit procedure. Plaint is nothing but a statement or a complaint which actually gives the whole concise statement of actual facts. What is the cause of action behind filing this suit, and also what reliefs the plaintiff seeks from the honorable court. This is basically a concise form of plaint which the plaintiff files. There are two parties to the suit. First is the plaintiff who actually approaches the court for the relief, and defendant, the other party, who actually says that plaintiff is not entitled to that relief. So plaintiff is the one who actually seeks the relief, defendant is the one who actually praise the court for dismissing this suit. So always there are the case between the plaintiff and the defendants. So suppose first the plaintiff has actually made that written complaint to the honorable court and filed it. After that, court actually checks what is the plaint all about. Then it orders to service of the summons. Service of the summons are governed by Order 7 Rule 2 of Civil Procedure Code 1908. Service of summons basically means that court actually, through its uh, presiding officer or by other appointed officer, signs a summons which actually tells the defendant to appear on this date along with his written statement or any other thing which is required by the court, and also gives the notice that the plaintiff has filed a suit against you and it will be proceeded against you if you do not come. So this is basically the service of summons. In the summons, there is also a copy of the plaint which is given to the defendant, so he can understand that on what grounds the plaintiff has filed and what is the basis behind filing of suit. Now, first I should tell you the brief description of plaint. Then we will go to the service of summons. And after that, suppose like briefly, if I tell you that after the appearance of the defendant is directed to file the written statement. Written statement is nothing but a concise statement which actually uh, is filed by the defendant, and by which defendant can admit the claim of the plaintiff, defendant can deny the claim of the plaintiff, and also if defendant thinks that he wants to file a counter claim against the plaintiff, then he can also proceed with filing the counter claim. So basically, what is written statement? Written statement is when the plaint is filed, the plaint is the statement of allegation. So now it is duty of the defendant to tell the court that whether this allegation has some substance, whether he admits all this allegation or he admits some of the allegation but denies the other, or he wholly denies the allegation or even the facts of the case. So it is the part of the defendant to actually tell his own version of the story. Once the plain and the written statement are given and no pending interim applications are there, issues are framed. Now, what I need to tell you is interim application. Interim application is nothing. Like suppose it always takes the time for the final adjudication of the suit. So suppose you want a temporary injunction, so you can file it on an IE. Or suppose your case is barred by limitation, so you need to file an interim application that con- that for condonation of delay. Like suppose you were supposed to file a case within the 3 years of the cause of action arise, but you didn't file it within the 3 years. Hence, you need to file now an interim application for condonation of delay. This is also an interim application. So first of all, such interim applications are decided, and later on, uh, issues are being framed. Issues are thing is suppose some of the points are admitted by the defendant, but some of the allegations are not. So issues are framed that whether these allegations of plaintiffs are true, whether plaintiffs are entitled to such reliefs. Issues are basically the points which needs to be determined by the court. So this is how issues are framed in a particular case. After that, hearing of the suit and examination of witness occur, which basically means that plaintiffs are asked to give their evidence and claim. Defendants then later defendant is also asked to give his statement and evidences, and based on the documents on record, the final argument has been done and then judgment is delivered. So this is the process behind the civil procedure court. Most of the time, what advocates or parties do who are a frivolous litigant, they actually file in interim applications so that its adjudication takes time and they can get undue adjournments. And that's why it takes years for the adjudication of a simple case. Now, I should briefly describe you the plaint. Plaint is a written complaint or allegation that contains following information: the name of the court, the name and description and residences of the plaintiff and defendant. It is very important aspect to know that where the defendant resides, what is the name of the defendant, what is the name of plaintiff, and all the parties to the suit. Also, the residences are very important because the notices are delivered their residences, and if their respective residences are wrong, then it would not actually be served to the party to the suit. Then the fact that constitute the cause of action. Cause of action means that why you instituted a suit against such person. What is the reason behind it? A cause of action is an essential thing in the plaint and it should be written very concisely. And if it is not written, there are chances that your suit will get dismissed at a very initial stage. So it should be written and very and it should be written by taking extreme care. Now, its facts also must show that the court in which you are filing your plaint has the appropriate jurisdiction for it. Then you should also write what are the reliefs you are claiming. You should also write how much court fees is payable by you and how much you have paid it. And if so, and suppose if you are relinquishing a claim, like suppose you are eligible for recovery of 1 lakh rupees, but you are only asking for 70,000 rupees, so that is a relinquishment of claim. Or a set of means when you are eligible for 1 lakh recovery, but you have already taken 30,000 from the defendant in some other transaction, so you can set off your claim. The value of the subject matter of suit is also very important because for determining the court fees, you need to actually value your suit appropriately. Then you must verify what are you stating as, and this is called verification. and you also need to file an affidavit along with your claim. Now we need to learn about service of summons. Service of summons is the process of delivering a summons to defendant to compel them to appear in court to answer the lawsuit. Here, answer the lawsuit is very important. Okay. Now, these are governed by Section 27, Section 28 of CPC, along with Order 5. So, how it is served? By delivering and tendering a copy of summons to the defendant. A copy of summons also contains a copy of plaint, and who signs a summons? The defendant may be required to sign a receipt on the back of the duplicate. Summons is actually signed by the presiding officer of the court. And then once it is delivered to the defendant, then the defendant is required to sign that he has received the summons of the particular court. Now, this is how service of summons work. What is a order 8 of CPC? It is basically on the written statement. So, what it actually says, the defendant is required to file a written statement within the 30 days from the date of service of summons. The time may be extended up to a maximum of 90 days by the court. So I have already told you about the written statement. This needs to be filed within the 30 days. But what actually happens is the written statement is filed much later because defendant actually files an interim application between it, and most generally the application under Order 7 Rule 11, which actually says that which actually is filed on the grounds that the said court has not jurisdiction, it is barred by some laws, or that the plaintiff has not given the copy of the plaint, or something like that. And adjudication of 711 takes time, and so defendants actually and generally do not file the written statement within 30 days or even 90 days. And once the 711 application is been decided, then they file written statement. So this is what written statement is. It also allows the defendant to file a counterclaim. Counterclaim meaning is that suppose maybe plaintiff may be entitled for some relief, but defendant is also entitled for some relief. So if defendant want to claim some relief from the honorable court, then he is required to file the counter. So now going to the interlocutory application that I have said, that these are like temporary injunctions or attachment before judgment, summary procedure for certain suits, production of document, appointment of dispatch. So there are different sorts of interim applications. I have written it in more detailed manner in this. You can go through this to understand what is the interim application. Now issues. So I have actually told you that Order 14 is the main thing which tells the procedure of framing the issues. There may be issues of law or issues of fact. The issues are framed after studying the plaint and the written statement. The court has also discretion to add frame additional issues if no point arises during the course of trial. Also, once the issues are framed, the court will direct the parties to produce evidence relevant to those issues. So here is so after this the evidence thing starts. I have given it in very brief everything. Then after that judgment has been pronounced. And this is the final culmination point of the entire legal process and is binding on the parties, subject to any appeals or revision allowed under the law. So, thank you for patiently listening to me today. I hope you have learned a great deal, and I hope you very best.